If you don't wish to appear on the recording, then please turn your videos off. If you'd like to access closed captioning, then that's on the bottom of your screen. Mine's disappeared, but if you hit more and then go to show subtitles, you'll be able to view them as we progress. Okay, copyright. Copyright is one of those really important aspects of our job that many teachers, including myself, seem to be perennially unsure about. When do we need a license at a gig or a concert? What constitutes an original copy of sheet music in the digital age? And many more questions that I'm sure will come through the chat shortly. So OneMusic has been created in an effort to make the process of copyright compliance a little bit easier. OneMusic is an APRA, AMCOS, and PPCA joint licensing initiative. It's been going since 2019, and it offers joint music licenses, making the whole process hopefully a little bit more seamless. They've recently released a guidebook directed at music teachers, and here to talk about all things copyright is a representative from OneMusic, Catherine McBride. So Catherine, we're so thrilled to have you with us. Where are you? Is she here?
You can probably hear me.
Oh, I can hear you and we can see you now. Fantastic. All right, I'll spotlight you and thank you once again for joining us and helping for us find a little bit of clarity around this issue. And over to you.
You're very welcome, and thanks so much for having me. Thanks everyone for joining the talk today as well. I recognise that talking about copyright at 8:15 on a Thursday night might seem a little bit of a tall order, but what I'm going to do is aim to, by the end of the session, have everyone feeling a bit more comfortable with the topic of copyright and dispel some of the myths that you might have heard before. And we're going to work through a lot of information because there's a lot of touch points with regards to vocal teachers and instrumental teachers. A lot of things that you need to be aware of, but we're going to work through it fairly systematically, and I will be sharing the slides with Shelley afterwards. So please don't feel like you've got to madly scribble everything down. You will get the slides afterwards, and within the slides there are links to parts of the APRA AMCOS website, the OneMusic website, where you can find more information about the things that we're talking about tonight. And I'll also share with you an email address where you can get in contact with myself or one of my colleagues in the team to answer any specific questions that we might not get to tonight. And we will have opportunities for questions throughout tonight as well. So I hope that by the end of it, you do feel a little bit less concerned about copyright. It's a topic that often makes people feel quite nervous, which is understandable because there is a lot of information and it is a legal area as well. But hopefully we can talk about it tonight in just an open and straightforward way, and all feel a lot more comfortable with it by the end of the session. So I will share my slides. This is always the bit where I hope that I'm not completely useless technically and that the sharing of slides will work. So let's give it a go. Oh, I need to share my screen first, don't I? That would help. Okay. Now, hopefully you should be able to see the slides okay. Is that working, Shelley?
Yes, perfectly.
Great. Okay. Okay, so I'm on the wrong slide. I just realized I'm at the end of my slides. That's great. Let's just try that again. There we go. No, sorry. See, I'm now demonstrating my lack of technical proficiency. I did actually click from the beginning, so I don't really know why this is happening. And now it's completely frozen on me. Okay, let me try this again.
This always happens. It works perfectly in
I
rehearsal.
know. It's what I might actually do is just open it up again. Apologies, everybody. Just talk amongst yourselves for a while.
It was the snow that did it.
That's it. Yeah. Right. It's really not happy. That's oh gosh. Okay. One more try. Okay. Right. Good. It's working now. Oh gosh. Okay. Right. So, as Shelley was explaining, we are going to be talking a lot about OneMusic this evening, and it is a relatively new initiative. Some of you may have heard of it before, but it's an initiative that APRA, AMCOS, and PPCA. PPCA stands for the Phonographic Performance Association of Australia. Sorry, Copyright Association, and we've come together to form a new organisation called OneMusic Australia. And OneMusic Australia brings together the rights involved in musical works and the rights involved in sound recordings so that people can get access to licenses that have the performance right for both of those things within the one license. So previously, say for example, if you were running, I don't know, an event where you've got some live performers and you've also got some recorded music, you used to have to go to both APRA and to PPCA to get a license, two different licenses for that one event. But now you can go to OneMusic to get a license that encompasses all of those rights together. So I'm going to talk a little bit about who APRA AMCOS is first, because as I'm sure you all know, APRA AMCOS has been around for a very long time, but still a lot of people aren't aware of exactly who we are as an organisation and what we do. So I thought, first of all, we'll deal with what the acronyms stand for, because we always get questions about that. So APRA stands for the Australasian Performing Right Association, and AMCOS stands for the Australasian Mechanical Copyright Owners Society. When we talk about mechanical copyright, we're really talking about the reproduction of musical works. So that might be making a recording of a musical work, or it might be something like taking a photocopy of some sheet music. So APRA was established in 1926 and AMCOS in 1979. And some of you might remember when the two were a separate organisation. So the two were joined together administratively in 1997. So now we operate as the one organisation. So what APRA AMCOS does is working with our composer, songwriter, and publisher members to make sure that when people use their music, we are licensing the use of that music, and the composers, songwriters, and publishers are being rewarded for the use of their work. As we go through the slides, we're going to talk a bit about the basic principles behind copyright and how that works. So some of the terminology that I use in the beginning might seem a little bit unfamiliar, but as we go through, hopefully you'll gain a good understanding of how copyright works and what APRA AMCOS's role is within that copyright system. So one of the myths about APRA AMCOS is that we are responsible for the copyright of musical works, which is not true. So as we will see in a minute, the copyright laws are federal laws, and APRA AMCOS's role is to represent the rights of copyright owners. So as I said before, our members are songwriters, composers, and publishers, and we work with them to provide licenses so that other people can use their music legally. That might include playing in public, copying, or communicating music. The license fees that we collect are then distributed back to those copyright owners, our members, as license fees. And if those licenses weren't in place, it would actually mean that each user of music would have to go to the copyright owners in order to negotiate how that music is going to be used and what fee is going to be paid to the copyright owner for the use of it. So OneMusic, as we mentioned before, is a joint initiative of APRA AMCOS, PPCA and ARIA, who I should have mentioned before, the Australian Record Industry Association, to allow the performance of music in areas such as the performing arts, retail, fitness and hospitality, with the convenience of having one license rather than having to go to the different organisations for different licenses. Okay, so to talk about some copyright basics now, the copyright laws exist to protect the rights of creators and the people who invest in them or the companies who invest in them. So that might be publishers or record labels, for example, and to make sure that they're fairly paid for the use of their work. And it's a crucial income stream for composers, writers, artists, other creators, and also the publishers and record labels. And the laws protect the rights of those people and actually encourage other people to be more creative at the same time. Okay, so we're going to look a bit at the Copyright Act. It's a very long act with a lot of complexity in it, but what we're going to do tonight is look at the very basic principles of copyright and the things that you really need to bear in mind as users of music and teachers of music. So copyright in Australia is governed by a federal law, which is the Copyright Act 1968. As with all legislation, it's updated from time to time. So there are constantly updates to the Act, but 1968 was the year in which it was enacted. The exclusive rights of creators are represented within the Copyright Act. We refer to it as a bundle of rights. And it includes the rights around musical works, artistic works, literary works, but also subject matter such as sound recordings and published editions. So those rights include the right to reproduce or copy, the right to publish, the right to perform or play the music in public, the right to communicate works to the public, and the right to make an adaptation or an arrangement of a musical work. Now, the copyright owner controls how their work is used in any of those ways, and anybody who wants to use it in any of those ways needs to have permission. As I mentioned before, we have licenses in place to license the use of music in these ways. And if those licenses weren't there, it would mean that as a user of music, we would need to go to the creators of the music individually to do any one of these 5 things with the music. Okay, copyright duration. This is a question that comes up a lot with myself and the team that I work with at APRA AMCOS. We get a lot of queries about how do I know if a work is in within copyright, whether it's still protected or whether it's in the public domain. So hopefully these slides will answer a lot of those questions for you. So the copyright in a published musical work lasts for 70 years after the death of the creator. And also arrangements are protected separately to the original musical work as well. So we'll talk about arrangements in more detail in a minute, but what this basically means is that if you're using a musical work, and by published we mean that the musical work has been recorded, written down. It could even be that somebody has written in inverted commas the music down using an electronic system such as Sibelius or a program like that. But once the music has really come out of somebody's head and has been recorded or put down in some way, the copyright protection lasts for 70 years after their death. And if there's more than one creator of the work, it's after the death of the last creator who dies. So if you've got, say, a lot of contemporary popular works might have been written by a band where every member of the band has contributed in some way. So in those examples, the member of the band who is the last one to die, to put it a bit bluntly, you have to wait until 70 years after that person's death before the musical work is then out of copyright and in the public domain. Published lyrics are also protected for 70 years, and they're classified as a literary work. So although, you know, most most songs, everybody would associate the lyrics with the music and think of those two things as the complete musical work. The lyrics alone are also protected. So if you wanted to say, I don't know, include lyrics from a song within a book that you're writing, even though you're not using the musical notes, those lyrics are still protected separately and classed as a literary work. Sound recordings are also protected from 70 years from the end of the first year of their release. And it's important to remember also that even though a musical work might be in the public domain, so say you've got a recording of, I don't know, a song by Mozart, for example, even though that musical work will be in the public domain, the sound recording that it's on will probably most likely still be protected by copyright because it lasts for 70 years from the date of the release of that recording. So unless you're using exceptionally old recordings, you will need to bear in mind that the sound recording is still protected. So some of you may be aware of this already, but in 2005, there was a change in the duration of copyright. So it was extended from 50 years to 70 years, but any works that were already in the public domain stayed in the public domain. So there's a fairly simple rule to remember, which is if the composer or all of the creators of the work died before 1955, then the work is in the public domain. So that's the simple rule to remember. Okay, now published editions, which is sheet music basically, or books containing music, are protected by copyright for 25 years from the end of the year in which they're published. So a little bit different to sound recordings. Sound recordings are 70 years. Sheet music is 25 years. And that also means that even if the musical work is in the public domain, the edition that you're using or the sheet music you're using may not be. So that may still be in copyright. And also important to remember that a work that is out of print isn't necessarily out of copyright. So there might still be a print publisher, for example, that has the rights to print that music, because the musical work itself is still in copyright. So it's always important to check with the publisher. Sometimes it's not always easy to identify the publisher that holds those rights, even though you might have, say, an old version of an original. Say it might be, I don't know, Boozy and Hawks, for example, and it's an old version and you're not sure whether it's still commercially available or out of print and or out of copyright. The holder of the print rights who has the right to publish that music may not be Boozy and Hawks. There might be an underlying print publisher. In Australia, the majority of the time that's going to be Hal Leonard, but other times it can be other publishers. So we're always happy to identify the correct publisher for you and help you, give you contact details for that publisher. So if you do have any questions about who published this work, you can always contact us on the email address I'm going to give you at the end, and we'll help you with that. You can find out more about copyright in general from the Australian Copyright Council. So at APRA AMCOS, we obviously deal with copyright all the time, but myself and the rest of my team included, we're not copyright lawyers. We're not intellectual property lawyers. So we only really sort of guide you on the basics of copyright. But for any in-depth copyright questions you might have, I would highly recommend going to the Australian Copyright Council, because they are copyright lawyers. And also they have some really great fact sheets. So you can look on their website for a particular topic or a particular area that you want to know more about, and see if they've got a fact sheet available. And you can also put in a request for professional legal advice as well. Okay, so we're going to have a look now at the things to bear in mind with regards to copyright when copying sheet music and making arrangements. And I will, after we've gone through these next few slides, I'll pause for some questions, but these slides sort of flow straight on from what we were just talking about. So I'll charge on with that now. So basically, the things that you need permission to do with sheet music is to make a physical and or digital copy of the sheet music. If the musical work and or the addition of the sheet music is still protected by copyright, which we just discussed. You also need permission to make an arrangement of a copyright work, and that includes making changes to the harmonic structure, chord progressions, melody, or lyrics, or to change the lyrics of a copyright work. Sometimes little tiny changes like changing he to she or things like that may not need permission from the publisher, but it's always best to check. Yeah, so those three areas are really important to bear in mind, that if you are making any copies of the sheet music, physical or digital, and that includes things that these days are just like super easy to do, and probably most of us don't think about it at the time, but you might be in a lesson, for example, and a student says, oh, I'm just going to take a photo of your music with my iPhone. That is a digital copy. So that's actually something that requires permission from the publisher of the music to do. So any kind of copying, whether it's scanning, taking a photo, sharing a PDF, making a physical copy such as a photocopy, it all requires permission. We're going to go through a few examples in a moment of limited times when you don't need permission, because you've probably all got a few questions about those things. So we'll go through that in just a minute. And So the other two important areas to remember are if you want to make an arrangement of a musical work and if you want to change the lyrics. So the way to get permission, which needs to come directly from the copyright holder, usually a print publisher, is to basically contact us or look up our work search. I would strongly recommend using the works search rather than sending us an email in the first instance, because it will be a lot quicker for you. We get a lot of inquiries, and although we do our best to get back to everybody as quickly as possible, you might be waiting a few days for a response. So this link here, which I'll make sure is working in the version that I send through to Shelley as well to share with you, will take you to a work search on our website, and you can put the name of the work and the composer in, and that should give you the name of the publisher. If it doesn't appear in the search, or if you contact the publisher and they say, no, that's not our area, because some of the works will show you the publisher that might deal with the performing rights instead of the print rights, you can email us. And sorry, that email address is actually incorrect, and I should have corrected it before this evening. It's actually education, which is even easier to remember, education@apra.com.au. That will also be on the last slide of tonight as well. So might be useful to jot that down. So yeah, just contact us or look at our work search and we will let you know who the publisher is that you need to contact. They will then issue a license on a case-by-case basis. So you'll contact them, let them know what the purpose is, what you want to do with the music, what the purpose is, and they will let you know if they can issue a license for that and how much it will cost. We do often get asked if we can give a ballpark to people of how much it would cost to get permission to make copies or to make an arrangement. And unfortunately, we're not able to, just because it does vary a lot from publisher to publisher and work to work. For example, if you were wanting to make an arrangement of, a very, very popular work that's, where the rights are held by, say, Disney, for example, that might be a whole different ball game as opposed to wanting to make an arrangement for not-for-profit purpose of a work by a local Australian composer. So it does vary enormously. So unfortunately, we can't provide any estimates on how much it might cost you. We do also recommend that you start the process as soon as you can, once you know what you want to do, because it can take several weeks. Sometimes the publishers in Australia might need to contact a publisher overseas to organise the rights. So we do recommend that you leave it as long as you can, as far in advance as possible. Okay, so just touching on arrangements now. This is also an area that we get a lot of questions about. Who owns the copyright in an arrangement? And that depends on whether the arrangement is in the public domain, whether the original work is in the public domain, or whether you're wanting to arrange a work that is still protected by copyright. So if the work is in the public domain, so in other words, all creators of the work have died before 1955, then you will be the copyright owner of your new arrangement. So for example, if you wanted to take, I don't know, a Mozart string quartet and arrange it for a vocal quartet, don't know if you would want to do that, but if you did, then you would be the copyright owner of that new arrangement, and you would have the same bundle of rights that we spoke about that exists in the Copyright Act. So that was reproduction or copying, public performance, publishing, communication, and anybody making any further arrangements would even have to seek your permission before they did that. So you would control how that arrangement is used in the same way that the composer of an original work that's still in copyright controls how that is used. If the work that you want to arrange is protected by copyright, and presuming you've gone to the publisher to get the permission to do that, the original creator or creators and the publisher or publishers will usually retain the copyright in your arrangement as well as keeping the copyright in the underlying original work. So if you wanted to arrange a work by, for example, a living Australian composer, or any other work that is protected by copyright, the creator or the publisher of that work would control the ways in which your arrangement is used, as well as the ways in which the underlying original work is used. So usually there would be some sort of agreement between you and the copyright holders that would spell out exactly what they're giving you permission for when you make that arrangement. So it might be permission to make an arrangement and perform it on a certain occasion, or to make a CD of that, of a recording of that work. So we'll just have a look at a little example, which is, can I legally copy this music without permission from the copyright owner? So this is sort of summing up a lot of what we just spoke about before we go to some questions. Well, actually, there's one more important slide after this before we do take questions. But when you're thinking about, can I copy this music without permission from the copyright owner, there's three really important questions to ask yourself. One is, did all the creators of the work die before 1955? The second is, if the work has been arranged by someone else, is the arrangement out of copyright? So remember, in the previous slide, we were talking about the fact that if somebody arranges a public domain work, they control the rights in that arrangement. So say a colleague of yours did that arrangement of the Mozart String Quartet for vocal quartet, they would control how that arrangement is used. So if that person didn't die before 1955, then they are going to be in control of how that arrangement is used. The third question is the edition of the print music that you're using more than 25 years old? And if the answer to all of those questions is yes, then copyright no longer applies and you can copy that music without needing to seek permission from anyone else. So that's probably a good slide to sort of sum up a lot of the questions that we often get asked about sheet music and the copying of sheet music. And when you get your copy of the slides, that might be one that you even want to sort of save somewhere or print out somewhere. Okay, so as I mentioned before, there are a few limited examples of when you can copy sheet music without permission. And these really come from a mixture of some what we call exceptions within the Copyright Act, and also some special permissions that publishers have given to make life a little bit easier for people using sheet music. So they include simplifying music on the original score or a part. So for example, if you've got a student who's having trouble with some high notes and you wanted to put them down the octave, or there was a run of semiquavers and the student can't quite manage that, simplifying that on the original part is absolutely fine. But of course, it doesn't involve arranging or rewriting the music to a great degree. Key changes or transpositions for rehearsal and performance are also absolutely fine, but you need to own the original. So you are making a copy by making that transposition and writing it out in that different key. So you do need to own the original to do that. Photocopying a page to help with difficult page turns is also fine, but it doesn't include the permission to photocopy the whole work and put the whole thing, you know, in a binder or something like that. It's only the odd page here and there. Also, making enlargements for a person who's vision impaired and requires that enlargement in order to help them read the music more easily, that's absolutely fine. And if the music that you're using or a student is using has an accompaniment, but the accompaniment doesn't come separately, it's in the one book and can't be separated out for the accompanist to use, you can make a copy of that for rehearsal and performance purposes as well. If you're making a copy of that accompaniment or the part for an exam competition or Eisteddfod, there is a copyright declaration form that we ask you to fill in, and there's a link there to that form. Okay, so having been through that swag of information already, which is probably quite a lot to get your head around already, we might see if there are any questions. So I'll just
Hi, it's Linda here. I've been monitoring the chat. Judy had 3 questions, I think. Judy, would you like to speak to those?
Hi.
Hi.
Thanks for this opportunity. I'm a composer as well as a singing teacher.
Mm-hmm.
If I simply print out a copy of my own music without a commercial publisher, is my work considered released or published?
Yeah, there are obviously a lot of composers who are self-published. So when we talk about a published musical work, as I said, it's any musical work that's been recorded in some way, so written down, put into Sibelius, an audio recording made of it, anything like that. So once your composition is put down in some way, then for copyright purposes, it is protected for that 70 years. So you don't have to go through a publisher. And also, I should have said as well, also in Australia, there's no process for registering for copyright. Your compositions are automatically covered by the Copyright Act in Australia. There's nothing that you need to do to obtain that protection.
Okay, so related to that, what does released mean in that context?
So released, released isn't a term that is really sort of used in terms of copyright protection. It's more released, I think, would, to my mind, is more if you decided to put your sheet music or go through a publisher to put the sheet music out into the public. So it wouldn't matter whether you had your written down score at home or you had released it to the public in some way, the copyright protection kicks in from the moment you write it down.
Mm-hmm. Okay. The third thing was, often in a lesson, a teacher will think, oh, now you should sing this song. You know, you need this right now. And I'm the only one who's got a copy of it, if I have. Is there a quicker way around getting copies? Consider, being able to make copies in that situation, presuming that there's no copy available to buy at the time.
Yeah, look, if there's no commercially available copy.
Oh, that's not what I mean. I mean,
okay.
in Melbourne,
yep,
you can't get a copy of it anywhere.
Yeah, no, I do understand.
Now, this teacher needs it the student needs this song now to deal with this particular, to practice this particular skill, or this deal with this particular technical issue or whatever.
Yeah, yeah. Look, I do understand where you're coming from. I'm actually a French horn player myself and used to teach French horn private lessons and in schools and that sort of thing. So I totally understand the dilemma. I guess the answer is not a terribly convenient one, I suppose. In terms of copying a whole musical work, there is no permission that's available other than if you go to the publisher to ask for that permission. What I would recommend doing though is checking with the Australian Copyright Council, because there's an exception in the Copyright Act called fair dealings, and people can make some copies under some circumstances for their own personal research, but it is under certain circumstances. And as I said, I'm not a copyright lawyer myself, so I wouldn't want to give you advice on that. But the Australian Copyright Council certainly could, and you would probably find the answer in one of their information sheets. So I would recommend going to them and asking that question.
Okay, thank you.
No worries.
I'm going to pick out a couple of questions that you might have a ready answer for. I mean, a quick answer for. One is Sarah asks whether replacing swear words in a song is okay.
Yeah, I think that would sort of come under that exception of, you know, changing it from him to her and that sort of thing. Those sorts of small changes to make something more acceptable for a student, I'm sure would be fine. Yeah.
And Rebecca asked why 1955, not 1951. In your questions, you said was the composer, did the composer die before 1955?
Yeah, it's because in 2005 the rules changed from being 50 years of copyright duration, so that would date back to 1955, and so in 2005 the rules changed to make it 70 years, but anything that was already in the public domain stayed in the public domain, because otherwise it would have been a bit unreasonable. So between 1955 and 2005 is that 50 years. But yeah, it's just a simple way of remembering that's it's easier than remembering the rule change, and what that meant is just think 1955, that's my cutoff date.
And Sandra, would you like to speak to your question? I'm not exactly sure of the situation you're referring to.
It probably was answered. It was just that because of the different durations, you're saying, well, if the music's out of copyright, it may be in copyrights. The sheet music may still be in copyright. I was just looking at the opposite, which is if the music is in copyright, but the edition is not in copyright, or doesn't that happen?
No, that does happen. Yep. So in those circumstances, generally the print publisher will still hold the print rights of that musical work that's in copyright. So it's important to check with them, you know, is this edition now out of print, and can I therefore copy it? Because they will still often hold print rights because the musical work is in copyright still.
Right.
And Kim asks about the tertiary education sector. Two questions. Can people working in that sector adapt songs and make arrangements for in-class activities? And can they perform them can they then perform them given that they're not receiving any money for it? It's not a non-commercial activity.
Right. Yeah, good question. So with regards to making arrangements in a classroom type setting, there are exceptions within the Copyright Act that allow you to make to write something out by hand or write out an adaptation of a work by hand, but not to make any further copies of that. So if you were doing it in a classroom type setting, or an educational setting where you or a lesson where you're just writing something out by hand, I'm sure we've all got students who've got the the staves in their practice books and that sort of thing. If you writing out music in there by hand and not making any further copies of it, that's covered by that exception in the Copyright Act. And that would include, obviously, making an arrangement by hand, but you wouldn't be able to make any further copies of that arrangement under that same exception. And in the tertiary sectors, universities have a blanket license through APRA, AMCOS, ARIA and PPCA, and they can opt into having print rights, which allows them to copy print music under certain circumstances, but it doesn't include making copies of an arrangement. So to make an arrangement and then make copies of that and perform it would still involve going to the publisher if you're in any educational institution. Yeah, you would then talk to the print publisher about wanting to make the arrangement and how you want to share that and how you want to perform that and under which circumstances. And if it is a not-for-profit activity, that may change the fees that they charge you. I'm not really sure about that. Does that answer
Kim
that
had
question?
a follow-up about Sibelius. He was referring to manuscript, but does that also include Sibelius as a digital manuscript?
Yeah. So using Sibelius, so going back to the copyright exception I was mentioning before, it only covers writing something out by hand. The way that section of the Act is worded really means that you can only write it out by hand, not using any kind of electronic device or any kind of device that will allow you to electronically copy. So yeah, it really does need to be by hand. Does that?
And this segues into another question from Victoria, which is if we own the hard copy, can it be scanned into an iPad and then read it for performance from the iPad?
There's no permissions within the Copyright Act that allow that, as far as I know. That would probably be a question for the Australian Copyright Council as well, just to check that, but I'm pretty sure that is not something that's covered by the Copyright Act, and it is something that you would need to check with publishers about.
Natalie's asked where we can find information about writing songs in lessons with students. Students hold the copyright. Is that the implication, Natalie?
Should I unmute myself to just have a chat?
Yes, please do. Yes.
We've got a couple of teachers, or one specifically, that really likes to help students with expression, and he's a wonderful songwriter as is, and so he essentially writes the songs with them in lessons for them, but gets a little bit of input, for the direction that they want to take the lyrics and whatnot.
Mm-hmm.
And helps them write. A concern or something we're trying to navigate is for future use of that song, does he hold the copyright to that song? Is it a combined effort where the student's name is put down on that as well? Or that's sort of the question, and I know that might be not able to, but is there a place we can find out answers for that?
Yeah. Look, as far as I'm aware, it would the copyright would lie with all of the contributors, and probably the best people to answer that question would be our writer services department. So the email address for them is it's just writer@apra.com.au.
Okay, perfect.
And they are really good at helping creators of music negotiate all of those rights issues. And they've probably got some handy tips with regards to how you work those things out and negotiate them, and making sure things are written down and that sort of thing.
Yeah. Okay. Thank you very much.
No worries.
And Rebecca asks about, well, she mentions that schools have limited permissions for copying musical works for school use. Are private teachers contracted by the schools also covered by those sorts of agreements?
In schools, the photocopying of music for the purposes of private tuition is not covered. And that can get a little bit confusing. So I'll use a couple of examples. So say, for example, there was a flute student whose teacher wanted to copy, a piece from Solos for the Flute Book 1 or something like that for the purpose of their individual lessons. That would not be covered by the school's blanket license. But if the teacher went to, say, the head of ensembles and said, look, my student's really struggling with their band part, I really would like to work with them in their lesson on it, then the school could make a copy of the band part for that student to work on in their lesson. So I guess, and the same would be true for an individual vocal student who might be learning their own things in their own lesson, as opposed to wanting to go through a choral part. You know, if they're struggling with that, they want to learn that in their lesson with the teacher. The difference really is that in the first example, the copy is purely being made for the purposes of the private tuition, whereas in the choir example or the band example, it's being made for the purpose of a school ensemble, and that's why that is covered by the school's agreement as opposed to the private lesson. So even if the lessons are happening at the school, in school time, and even if the teacher was a member of staff at the school, the thing to remember is for the purposes of private tuition, photocopying or copying music is not covered.
And Judith asks whether singers can use YouTube backing tracks in a performance. Yeah,
it's a good question. Really, that comes down to more to YouTube's own terms and conditions. Because as we'll see when we go through the next few slides, there are public performance situations where a OneMusic license will cover you to use sound recordings as well as perform live in public. But it's good to be aware of the terms and conditions of a service like YouTube, because sometimes a lot of the time they will have in place terms and conditions that mean that it's really only for private and domestic use. So that would be my recommendation there.
And Eric was asking the differences for works covered by grand licensing.
Yeah, we're going to go through that as well. So yeah, grand rights works. We're going to work through that in the next few slides as well.
And so we may be preempting what's coming up. Intellectual property, does that come up soon? Gary was asking about whether the Australian Copyright Council is the place to go for protection of IP.
Yeah, so so copyright is a branch of intellectual property, if you like. And so the Australian Copyright Council deals with intellectual property that is protected by copyright. So there's other types of intellectual property that are protected, for example, by patents or that sort of thing. So the Copyright Council specifically deals with things like musical works, literary works, dramatic works, artistic works, those sorts of things that are protected by the Copyright Act.
Thank you. I think that's everything.
No worries. Okay, I'll share my screen again. So hopefully the slides work again better this time. Oh, and we've gone back to the beginning. Never mind. Technology is not my friend at the moment. I will just fast forward through everything that we've gone through. not sure why it doesn't work when you say start from the current slide, but anyway. Okay, so we're going to start looking at some of the areas of the use of music rights that are covered by OneMusic licenses now. So performing music in public. So the responsibility for having a license in place to cover the public performance, because remember, performing in public was one of the bundle of rights in the Copyright Act that's exclusive to the creator of the music or the copyright holder. So the performance of music in public requires licensing, and it is generally the responsibility of the person or the group organising the event to have that license in place. Sometimes the venue as well might be the person who holds that license. If you or your students are performing at an event or competition or anything else that's organised by another person or another organisation, generally you won't be the person needing to obtain the license. That should be in place already. But of course, you might still need clearance for things like your own copies, arrangements, lyric changes that we've already been through. Okay, and if you're holding an event yourself, you've organised it and you're holding the event in a public place, so it might be an end of year concert or student soiree, something like that, that's where you will need to make sure that you've got the license in place to cover the public performance. As I said, the venue may already have a license. You can confirm that with them, or you can check with us using that email address. And if the venue doesn't have a license, then you will need a OneMusic event license. And there's a link to the information about that there in the slide. Playing sound recordings in public. So this is where the YouTube example would come into play. It is different to playing live music in public. So APRA licenses the public performance of the musical works. So if somebody is singing in public, for example, then the performance rights being used there are held by APRA. But if it's a sound recording that's being played, then the right to perform that sound recording is held with PPCA. So when a sound recording that involves a musical work is being played in public, both those sets of rights are in play. So the public performance of the musical work and the public performance of the sound recording. So this is where OneMusic brings both of those things together so that you only have to get that one license. So there's information there that's available to you, and you can contact the team at hello@onemusic.com.au. When it comes to a Stedfordo, I should be correct about that, competitions and exams, or examinations, if I'm going to be really proper, you do need to ensure that your students are performing from legal sheet music. So that's either the original published edition or a legal copy of an original score or an original edition. There's a OneMusic Australia Eisteddfod and competition license that is held by the organisers of those events. So that's not something that you need to take out yourself if you're a participant or your students are participants in an Eisteddfod or competition. But it does allow the entrants to use sound recordings or commercial backing tracks as part of their performance. And you can contact that email address. If you run an Eisteddfod or you're involved in an Eisteddfod or you just have more questions about it, feel free to use that email address. And as I mentioned before, there's a copyright declaration form for when you're making or your students making copies for an adjudicator or an examiner. So as I said before, with the example of using YouTube in performances, the YouTube, the audio that's being used is a sound recording, obviously, and the OneMusic license covers the use of sound recordings, but you do need to be careful that you're abiding by YouTube's own terms and conditions as well. Okay, now music in community groups, there is a special OneMusic license for community music groups as well. So if you run your own group or you're part of a group, this will be relevant for you. So bands, choirs, and other ensembles or groups that have public performance of music as their primary purpose have access to a OneMusic community group license. And it covers live performances at community events. I believe they are events that are with free admission. I'd have to check that, but there's a link to the information guide on this page too, so you can check that out if you need to. It also covers making audio recordings of performances and practice and rehearsal copies, audio copies for the singers or players to help learn their music. And there's an option to cover the making of copies of print music as well, but it's for rehearsal and archival purpose only. So for performance, each member of the ensemble has to have an original copy. Either they will have needed to buy it themselves or the ensemble will need to purchase it for them. So there's a link to more information about that. Oh, it's interesting. That's gone in a completely different direction than what I expected. Okay, musicals and music theatre. I think there was a question about this, so hopefully this will answer your questions. So the use of music in theatrical productions is a little bit complex, but we're going to break it down so that hopefully it doesn't seem too complex after this. But it does require a bit of forethought and planning. So the obtaining of permissions can be a little bit complex, so it's good to leave a really good lead time before you need the license in place, and to also have some backup songs ready in case you can't get the permissions for the songs that you want to use. So there are two types of use of music in a dramatic setting or in theatrical performances. One is what we call dramatic context, and the other is grand rights, which somebody has already asked a question about. So looking at dramatic context first, this is where pre-existing works are used in a musical. So it could be popular songs, and there is a definition of dramatic context, which is music that's used in conjunction with a presentation on the live stage that has one, a storyline, and two, one or more narrators or characters, or it's music used as a ballet. So OneMusic can license some works for dramatic context performances, but some music has to be licensed directly through the music publishers. So this is why one of the reasons why we suggest having a long lead time so that you can navigate through that. There is a link there for more information. And if you're using sound recordings in a dramatic context, we recommend that you contact PPCA because they control the use of sound recordings in that context. Okay, looking at grand rights now. So grand rights is where there's a dramatic work that includes music that's intentionally composed and created to be performed together with that dramatic work. So typical musicals, Cats, Wicked, Broadway stage shows, operas, operettas, that sort of thing. And if you want to put on a grand right work or a musical in its entirety, that always requires licensing from the rights holders. So publishers that hold these rights. And three of the places that we would recommend that you look for the rights to put on musicals is Musical Theatre International, or MTI, Origin Theatrical and Hal Leonard Australia. So those are the three organisations in Australia that tend to hold the rights for most of the musicals that are popular to put on. And they will put an agreement in place, a licensing agreement in place directly with you to put that musical on. And it's a sort of a package where you get all of the parts and the sheet music and the script and the books and the whole thing, and the public performance license. And it's important to abide by the terms of those agreements as well, which usually involve not photocopying the music, and probably, I would say, mostly involve not making recordings of the performances as well. But that would be something to check directly with those publishers. Okay, are there any quick questions about that before we crash into making and sharing recordings?
There was one quick question from Kim, whether Eisteddfod licenses include tertiary exams?
No, tertiary exams would be covered either by the Tertiary Music Agreement, which is in place in universities, or by the Copyright Act.
And Rebecca asked about online sheet music sites like Music Notes. Rebecca, would you like to unmute yourself and talk to that question?
Apologies for keeping my screen on the slides, by the way. I think it might just save the technical issues afterwards.
Yep. So the question I had with musicnotes.com is one that a lot of my students print or they pay for songs and they print them off for individual use. When we used them at an Eisteddfod up in Alice Springs, the only stipulation around it at that point was if the local music shop could not source that music, that they would then stamp it as approved because it could not be sourced anywhere else. And he had a particular, I think it was either APRA license or one of them where he was authorised to do that so that it could be used in the Eisteddfod. With the huge amount of different online sources and things that we're getting nowadays where you can purchase more online sheet music, is there more issues sort of cropping up around that because they're not Australian sites? So how does that work with the licensing here in Australia?
Yeah, that's a great question. So first of all, APRA AMCOS has reciprocal agreements in place with other rights organisations all around the world. So when you're using music in Australia, it's not just Australian music that we represent. It's music from literally just about all around the world. So there are very few musical works that we don't represent. So that's the first point, and I should have made that point at the beginning. Apologies for that. The second point is that if you have purchased a PDF of music from a legitimate source, such as Music Notes or Sheet Music Plus or something like that, JW Pepper, those kind of sites where you're purchasing a PDF instead of a hard copy original, that is your legal original. So usually I think that they come with an agreement where you can print out one copy as your hard copy original. For the purposes of an Eisteddfod or an exam or a competition where you're asked to submit the sheet music to the adjudicators or to the organisers, making a photocopy of that printout is the same as making a photocopy of a hard copy of music that you've bought from a music shop. So there shouldn't be any problems submitting that to the organisers of the Eisteddfod. If they do have any issues with it, I would recommend that they contact the Eisteddfod email address that was on the slide earlier, because from our point of view, that printout that you make is your original. So making the photocopy for the adjudicators should be exactly the same deal as if you'd gone and bought the physical original from a music shop and made a copy of that.
And Kim had a question about dramatic context. Would 2 songs from the same musical be count as that? And 67 minutes of a grand rights piece is possible. Are those 2 things? I've tried to summarize it, sorry.
Yeah.
Yeah.
So if you're performing a song from a grand right work as a concert performance, that's not something that you would need to go to the holder of the grand rights work for. So it's if you're performing the entirety or a substantial part of the grand right work where you would need to go to the publisher. I should also point out that there are some copyright elements in grand right works that are separate to the musical work. So, for example, costumes, script, sets, choreography, those sorts of things that would be protected by copyright as well. So if, for example, you were to sing a piece from Cats, one of the songs from Cats, and you were dressed in a cat costume, that's going to engage the copyright protection of the costume as well as the musical work. So although OneMusic can give you a license to sing the song, because you're not putting on the whole musical, we can't cover you for the use of the costume. So if you want to use any other original elements that go along with that song from the original musical, that's when you would also have to contact the publisher for that permission. So if you're thinking about performing in public, just bear in mind that the OneMusic licenses cover literally the music and the sound recording. Does that
Kim,
answer that question?
Kim, did you want to talk to that? Is that an answer for you? Oh, okay. It looks like maybe we can move on. Thanks.
Okay.
Kim.
Look, I'm very aware of the time, and there are probably some slides in here that I will not get to tonight, and I'll just leave with you when you get your PDF copies of them with regards to educational blanket licenses. But I think with regards to schools, we've probably covered the main issue already, but I will quickly go through these next few because I think they're probably more important. So the making and sharing of recordings, for audio recordings only, so just sound, no video, you do require a license or permission if you're making audio recordings of copyright works, and that would include for learning tracks, accompaniments, and any professional recordings. If you're making copies of existing sound recordings, so you might be copying them as an MP3 or as a CD. You can see from my backdrop before, I'm a bit old school and have lots of CDs, so hence the reference to CDs in there. Or if you're making audio only recordings of copyright works and you want to make them available for download or streaming, so that will include if you're emailing them to someone, making backing tracks that people can download, or if you're uploading anything to a website or social media. Or if you're making copies of existing sound recordings available for download or streaming as well. So whether you've recorded yourself singing or a student singing, or you're using an existing sound recording for audio only, you do still need permission to do all of those things on that list. You can get more information from those sources. And looking at audio visual recordings, again, permissions required if you want to make audio visual recordings for domestic use. So for example, if you wanted to record your student's end of year concert and then give a copy to all of the parents, that does require a license. If you want to make those video recordings publicly available, including posting them online or entering them into a competition, Obviously, for commercial purposes, licensing is required. And when it comes to audio-visual recordings, because you're pairing the audio element with the visual element, it usually requires permission not just from APRA AMCOS or not just a license from APRA AMCOS, but also permissions directly from the rights holders. And we call that synchronization rights. So even if you're making a video of a concert where the video is literally the performance of the works, because there is a visual element and an audio element, then synchronization rights are required, and they usually come directly from the publisher. And again, for more information, there's an email address there that you can contact. Okay, are there any questions about that? Well, we're actually out of time already. But what the slides that I had left were going through the blanket educational licenses, but I'm pretty sure I've got listed on those slides everything that is included and not included in those licenses, which includes schools, unis, the commercial colleges, and TAFEs as well. So
I'm happy to go a little bit over time if you want to get through those slides. And just to say to anybody, if you need to leave, then you can catch up with the recording once we post it up in the member resources section.
Sure. Yep, that's absolutely fine. Okay, well, I'll keep going with them then. And I guess if there are questions that come up, maybe Shelley or Linda, if you want to email them to me, then I can get back to you in writing and you can share them with the group as well. Okay, so blanket educational licenses, as I mentioned, we'll go through schools, tertiary music agreement at universities, TAFEs and commercial colleges. Oh, and also conservatoriums. Okay, schools. So some of you probably know that up until now, there's been 3 license agreements in place at schools. So there was an APRA performance agreement, there was an AMCOS print music or photocopy agreement, and there was, it had a very long title, but we used to call it the audio visual license, which involved APRA, AMCOS and ARIA. At the moment, we're currently working with the National Copyright Unit, which looks after all things to do with copyright in schools, to introduce a new comprehensive music license, which will be all of the rights that were in those 3 licenses in the one license, and also some additional rights. So the additional rights that are of most interest, probably to talk about tonight, is the copying of sheet music digitally, because up until now, schools only had permissions to photocopy sheet music. So it now includes copying music digitally, so sharing PDFs or making a scan of an original hard copy, and sharing recordings of school events online. So previously, that involved getting synchronization rights from publishers, but now schools have permission to share video recordings of their school events online. Okay, so almost every school in Australia has this license in place and will automatically go onto this new interim license, having had the 3 separate licenses previously. And then once the new permanent license is in place, we'll also automatically go on to that permanent license. All government schools are automatically covered through their state departments of education. Independent and Catholic schools in Victoria, independent schools throughout the country and Catholic schools in Victoria opt in through their peak bodies. And for Catholic schools in other states other than Victoria, they are automatically covered through the Catholic Education Office. Independent schools and Catholic schools in Victoria are almost entirely covered by the license. So it's very rare that a school is not covered by the license. So things that are covered under school events and concerts, we've got public performance at events directly associated with school activities, and that can be on or off campus. So if you're conducting a choir at a school and you maybe are involved in a gala concert or a speech day or something like that, even if the school is holding that at a local town hall or something like that, it will be covered by the school's blanket license. Using music in a musical or play written by a teacher or a student. So that's the dramatic context that we were talking about before. So schools are covered to perform music in a dramatic context. Making audio or audiovisual recordings of a school performance or event. Uploading those recordings to an education app. So that will be one that's primarily used by the school to communicate with the school community, and also to share school events and performances or recordings thereof on a school website or official school social media channels. So that's a very new permission that has only been included in this new interim license from this year. We obviously don't have any control over takedown notices that are issued by third-party platforms. So if school performances are put on Facebook, for example, we obviously can't control the bots that may issue takedown notices, even though this license is in place, because obviously Facebook doesn't have insight into what our license covers. Also sending recordings to members of the school community or live streaming a school event. I'm just whizzing through these quite quickly, but as I said, you'll get the slides afterwards so you can have this in writing. Now, pairing music with unrelated visuals. So we were talking about synchronization rights before, which is involved anytime there's audio and visual elements at the same time. There's different rights involved, whether the visual elements are related to the music or unrelated. So in terms of related, we're talking something like a video of a concert. So you're videoing the performers playing or singing those pieces of music, and that visual is directly related with what we're hearing. If it's unrelated, it's more like a slideshow that might have a commercial track behind it, or a recording of the school performing a work, but you've overlaid that with a, I don't know, some drone footage of the school or something like that. We see those sort of really impressive looking videos more and more these days from schools. So if you're incorporating a musical work or sound recording into an educational video, slideshow, PowerPoint presentation, or anything like that, and you can share those files with the school community. Now, when it comes to print music, as I said before, physical and digital copies are now covered. The school must own the original, or a teacher at the school must own the original. And the number of copies that can be made is limited to the number of staff and students needing to use that music for the educational purpose. So if you were directing a choir, for example, and you had 45 students in your choir, then you would be able to make 45 copies of a score. There are some different limitations where it comes to choral sheets. So you're probably all quite familiar with the choral sheets that are, only sort of a couple of dollars each to buy. There are some different limitations around them, and we're in the process of finalising the wording around that. So Shelley, perhaps you can remind me to share that with you when it's been finalised, so you can share that with your members as well. Making a transcription of original print music. So by transcription, we mean a direct copy, but it's usually something that's made by hand, which we spoke about earlier. Or it might be that you own the sheet music of a song, but you just want to write the lyrics out. That's okay as well, as long as you own the original. And other uses that are permitted under the license include using music as a school bell or in communal spaces, using on-hold music on the telephone system at the school, playing a film for entertainment. Yeah, so those are 3 other examples that are commonly asked of us, whether they're included under the license. Now, you might need further permission. In fact, you will need further permission for all of these things. So performing a grand rite work in its entirety. So although schools have permission for dramatic context, where the school has written their own musical, if you want to perform an existing musical or an existing operetta or opera, you will need to go to the publishers, just as we discussed before. We've discussed this one before as well, making copies of print music for the purposes of private instrumental or vocal tuition, and making print arrangements where the nature of the work is altered, so melody, harmonies, lyrics, that sort of thing, and any commercial activities. So where the primary purpose is advertising or promotion of the school or of a third party, but the promotion of students' work or a school event is permitted. So if you had a video of the choir singing a piece of music, and that was to highlight the fact that they're singing in a concert next week, that's absolutely fine. Or if a student had written a fantastic choral piece and you wanted to showcase that on Facebook, that would be fine as well. Okay, so we'll go on to the tertiary music agreement, which is in place at all 39 universities that are under the Universities Australia umbrella, which is just about every university in the country. They have in place what we call the tertiary music agreement, which is also quite new, actually. It came into place at the beginning of 2020. And there is an optional print music license under this agreement as well. I think there's only about 9 universities that have taken that up. So that covers photocopying of music and also making digital copies of music, but only at those 9 universities that have taken that out. If anybody has any questions about whether a university that they're lecturing at or teaching at is covered, just get in contact with us at that education email address that will be shared in the last slide. Okay, so the examples of activities covered under the tertiary music agreement, a lot of things that are very similar to the school license, but they are obviously very separate agreements. So there are some differences that are important as well. So this is one of them. So public performance at university events, but there's a limit on the ticket price. So the ticket price must not exceed $40. Otherwise, the university would need to get a OneMusic event license. At graduation ceremonies, there is no ticket limit price, limit on the ticket price. It also covers background music in university spaces and businesses, as long as they're 100% owned by the university or an affiliated institution. And these are all things that we worked through with the universities. So as I said before, if if an organisation is organising an event, it's really that organisation that's responsible for the licensing of that event. So if you were asked to perform at a university event, it's not your responsibility to make sure that that license is in place. It would be the university's responsibility. Universities, as you probably know, often own fitness centres and childcare centres. They're also covered for their music use, but only if they're only open to staff and students. Also, student unions, association, guilds and clubs that are 100% owned by the university. And obviously, universities are covered for their educational use and university purposes. They are also covered for making audio and audiovisual recordings. And a lot of this is very similar to the schools. So I'll just go through that very quickly. Yeah, I don't think there's anything there that's really terribly different to the school's license. As I mentioned, print music, again, very similar to the permissions in place at schools. And further permission is required, as I said, if the ticket price exceeds $40 for a university event. Use in a dramatic context, that is something that is different to the school's license. So universities are not covered to write their own musicals or use music in a dramatic context. Performing grand rite works and choral works longer than 20 minutes. That's a rarity. It'd be things like Carmina Burana and that sort of thing. If you're performing the entire work that's longer than 20 minutes. If universities want to share videos on their social media channels that capture sound recordings being played at university events and performances, they do need additional permission for that. But again, unless you're organising those videos, that won't be your concern, thankfully. And if universities are sharing any audio or video recordings with staff and students, they need to be streamed only and not available for download. And commercial activities are not covered as well. So that was a very, very quick tour. Sorry, making print arrangements too. Very quick tour of the university's license there. But as I said, I will make sure that you have all of this in writing. I'm only going to very briefly touch on the TAFE license. I'm hoping that that doesn't affect anyone. If you are a teacher or a lecturer at TAFE and you would like more information about what's covered, feel free to email us, but I've only just put a couple of very brief points in about these ones. There are whole of TAFE blanket licenses in place in most states. And in the states where they're not in place yet, we're working to transition into those blanket licenses. And the structure of TAFEs in Victoria is quite different. A lot of them are run through universities, so where that is the case, they are covered by the tertiary music agreement in place at universities. So there are some examples there of what's covered. Oops, just leave that there for a second. Probably the main thing that is not covered under the TAFE license is the print music rights. So there are no rights within the TAFE license to photocopy or make digital copies of print music. But other than that, a lot of the rights are similar to schools and universities with regards to making recordings of things and sharing those recordings and playing music at live events. Okay, and commercial colleges, again, some similar rights with regards to performance and making recordings. These licenses also do not include print rights, so no photocopying or digital copying of print music. And the sorts of colleges that tend to have this license in place are a lot of the sort of heavy music users, so JMC, AIM, SAE, Afters. I'm sure I've forgotten a few others as well. There's quite a few of them with this license in place. And last but not least, conservatoriums. So conservatoriums are a bit unique in that almost all the conservatoriums around the country these days are technically music departments of universities. So they're actually covered by the universities agreement or the tertiary music agreement. Where they're not part of a university, so for example, all the New South Wales regional conservatoriums, they have their own license that covers, again, many of the same rights, so public performance, making recordings and sharing recordings, and also making copies of print music. We're looking at those agreements at the moment in terms of whether they need some modernisation because it's a while since they were put in place. Yeah, so that is actually a very quick run through all of the educational blanket licenses, just to give you a sense of what rights are covered in those agreements in schools, universities, TAFEs, commercial colleges, and independent conservatoriums. I'm sure that there are probably a lot of questions about those areas. But I think given the time, we might suggest that if there are any questions coming up in the chat, that they're emailed to me and I can get back to you in writing, and Linda or Shelley can share them with everybody.
Yes, absolutely. And thanks so much for offering to do that.
No, that's fine. I'm just going to, sorry, there's a brief slide about becoming a member of APRA AMCOS if you have written your own music. It's very easy. You go to our website and follow the prompts. And I'll just leave that slide there for a second so that everybody's got the education email address. And as I said, feel free to contact us with questions. We're more than happy to help. Apologies if it does sometimes take us a few days to get back to you because there are lots of questions coming in all the time, but we're happy to help where we can. And there's a live chat option there as well.
Fantastic. Thank you so much, Catherine. We really appreciate you taking the time to take us through this very complex but super important issue for us. My takeaway is no more cat costumes for me in performance. And thanks also, as you've mentioned several times, that members with particular questions can contact OneMusic for further advice, and we'll also share the slides of what you've presented today. So hopefully that'll be a useful resource. I neglected to mention before, but I did want to pay particular thanks to the Queensland chapter for bringing the mental health first aid course to our attention as something that we should or could make as accessible as possible to our members. So shout out to Queensland for that. And also thank you to Linda for your excellent facilitating of our questions tonight.
No worries. Oh, I've just realised, how long have I been unmuted? Thanks, guys. Great to see you all. And thanks to our presenters.
So that's it for tonight, folks. Thanks once again for joining. I can see there's some dwindling numbers, but thanks for sticking through to the end. Just a quick reminder that it's chapter AGM season this month, and I want to really encourage you to get along to your chapter AGMs if you possibly can. Have your say, meet your local committee. There have been some inevitable date changes with COVID, but your chapters should have kept you informed. I'll just quickly whiz through the dates. Tasmania is the 3rd of August, South Australia and WA is Sunday the 8th, Victoria and ACT's Sunday the 15th, Queensland and New South Wales Sunday the 22nd. somebody correct me on the chat if I'm incorrect there. But I also wanted to draw your attention to the New South Wales Musical Theatre Workshop on Sunday the 8th, which I believe is moving online now for obvious reasons, and the West Australia's perennial annual Sing Into Spring on the 28th of August. So all up, it's quite a busy month. We also have a mentorship program starting on Sunday, so I'm really looking forward to that. So Catherine, once again, thank you. You've been on Spotlight this whole time. Hang on, I'll just take you off.
No, you're very welcome, and thanks everyone for your patience. There's so much to get through, and really appreciate you hanging in there.
Oh, no, it was fantastic. You was presented in a very digestible way. And we'll pop the recording of the copyright webinar onto the member resources section of the website, which you access via your member login. I hope you've all managed to do that at some point in the last 12 months. If you haven't and you have trouble working out how to access that, just let us know, because we're happy to help you. There's lots of really great things on there that you can check in with. So yes, all that remains is to say stay safe and well and take care of yourselves in these weird times that we're living through. And goodbye until next time. Thanks very much, everybody.
Thanks. Bye.
Bye.